The subject of this blog is common misconceptions about personal injury lawsuits. I don't know if these misconceptions are fueled or made worse by so many television programs that deal with law and trials, but be that as it may, there are a number of things I would like to point out, some of which you may be aware and some of which may surprise you. The first is, in every injury case or every accident case, we must know what the insurance coverage is of the adversary. It is a very different proposition if there isn't enough insurance and you're going after somebody personally. So that's something that you need to know about. The news is good on that front because you can find within 30 days what the insurance coverage is on the entity or the person you're suing simply by sending a letter pursuant to a Massachusetts statute. That is Chapter 175, 113L. And that has made life easier to know what the parameters you're facing right off the bat. But one major misconception that people have is the frequency, the speed, and the accessibility of jury trials. The first is, how common is a jury trial? And the system has in place a number of methods: mediation, arbitration, a protracted course of discovery, all of which lend themselves to resolution before a jury is impaneled. I should also say that there can be a resolution after the jury has been impaneled, or indeed even after there has been a verdict. But there are many parts of the system that are in place to encourage settlement. The second is the length of the trial. Our TV shows typically show an hour-long trial. Trials of a significant injury where the facts are in dispute will go on more than a week. They will be usually scheduled from 9 to 1 each morning, and it is very easy for such a case to go into the second week. And finally, the time it takes to get a trial can vary. When I started practicing in the early 1980s, it was a much harder system. The system would not really grant speedy trials. And as for the notion of a speedy trial, you could only get it if one of the parties was over 65 years of age. But now, through things like scheduling orders and tracking orders, you can get your case tried fairly quickly, at least when compared with how it was 30 years ago. Nevertheless, you will not get it tried all that quickly in relation to when the injury or the cause of action arose. Now, I've spoken in the past, and I'm on to a new issue of misconceptions, that I've spoken about people or jurors getting the case on special verdicts. Special verdict forms are questions the jury is asked. And one of the most wrenching is the second question: was the negligence of the defendant a substantial contributing cause to the plaintiff's injury? That second question can be a trap, it can be a pitfall, and it always needs to be discussed with the client. In a recent blog, I spoke about the burden of proof in a civil case, and there is good news on that. That is that you must show, one might say, merely by a preponderance of the evidence. Now you can say, why do I put this, the standard of proof, in this blog? And that is because it's a misconception. Some people think it's the criminal standard of reasonable doubt. It's a misconception that, when clarified, actually helps us. And then I want to focus on the cost, not only of trials, but of preparing a case for a trial. And that comes in the nature of experts. Expert witnesses are people with specialized skill and knowledge. They could be doctors, they could be engineers, and to be candid, they don't come cheaply. And those are expenses that are borne by my office, but at the resolution of the case, if favorable, it will be adjusted such that it will be paid out of the client's share. Any case that is properly prepared will have experts, and those are expenses you want to be familiar with and monitor and not be surprised. Now finally, you should always keep in mind, and I've blogged extensively over the years about this, that a trial has rules of evidence, and rules of evidence have many rationales, and sometimes relevant evidence, evidence that you think is apt to show certain conduct and things of that nature, relevant evidence will not be admitted because of various exclusions. And this has come about through input from the state legislature and input from the courts. But it's not a case that you can get up and narrate a story without running afoul of certain evidentiary issues. Those two, to the extent possible, should be explained to the client. Hopefully now I've clarified some of the misconceptions of personal injury lawsuits, including the availability, the duration, and the nature of trials. Thank you.